Kumar,
how
you
she
are
does it.
into multitasking today. She is attending to, I think, yeah. So should we start?
Thankanjan, so yes, please, we can start with, it's
Yes, yes,
already
we can
5
start.
to, we can start.
Yes, we can start. Now it is 5
It's
5 o'clock.
correct. Yes. Yes. All right. So, good evening, everyone, and a very warm welcome to all of you in the second class of EMW Generation Next Classroom Series 1 of 2021. It is wonderful to see so many young students, friends with us today who have joined from all across the country. Most of you are aware that this classroom series is being held under the banner of E-Mediation Writings, an online magazine which was launched on 1st of June 2020. The ground rules of the e-classroom series has already been spoken about by Shiraz sir in the inaugural session of the classroom, and so they remain the same. However, I can add that we have assigned around 30 minutes for the interactive session, and we request the participant to write down their questions if they want in the chat box, which will be taken by the student moderator today, and will be answered by our teacher speaker after his deliberation on the topic is complete. And maybe in between also, as Shiv sir has agreed. All the young friends are requested to keep their videos on and mic muted throughout the session. That will probably help the teacher to impart the education in a better manner. So let me now introduce you all with our team of today's e-classroom. I am Anup Kumar Srivastav, an advocate, a mediator, trainer, and state coordinator of e-mediation writings. Our young friend Aditya Vadhva is a student of law, the fifth year as he told us, from NLIU Bhopal. And he'll be moderating with the questions. And our guest teacher speaker today is Shiv Kumar sir, who will answer all those questions. And you all are aware that the real force behind the EMW Generation Next Classroom series is Ms. Pushp Gupta, advocate, mediator, trainer, and the coordinator in chief of e-mediation writings, along with Mr. VP Thankachan, advocate, mediator, and a senior trainer, and also a senior member of e-mediation writing. So we all are indeed privileged today to have with us, Shri Shiv Kumar sir, the teacher speaker of the day. He is an advocate practicing in the High Court of Karnataka, a senior mediator and a master trainer at the Bangalore Mediation Center. Mr. Shiv Kumar has completed 40 hours commercial mediation course of the Ministry of Commerce and an advanced training in commercial mediation conducted by the US Commerce Department. He has written several wonderful articles on various aspects of mediation under the Generation Next Classroom series. These articles have been published in EMW magazine, and from October on editions onward, you can find those articles. I have read all those articles, and I can vouch that I loved his lucid style of writing, and I have a great respect for his immense knowledge on the subject. I would recommend all my young friends present here to read those articles and to enrich their knowledge on mediation. Shiv Kumar sir has a vast knowledge and experience in the field of mediation. Our entire EMW family has great love and respect for Shiv Kumar sir. Sir, you are welcome.
Thank you.
Our attempt at holding e-mediation writing Generation Next Classroom series is not a mere formality. We have designed the topics on mediation strictly in accordance to the syllabus of mediation prescribed by the Bar Council of India for the law courses. Our guest teachers are senior mediators and trainers who have vast experience in mediation training. So our young friends are going to be greatly benefited from this EMW classroom series. Now let me introduce you to the topic of the day on which our guest teacher speaker will be addressing you all. It is the elements of mediation. Mediation, as we all know, is one of the alternative dispute resolution mechanisms provided under Section 89 of the Code of Civil Procedure. Mediation has no statutory definition assigned to it so far, and therefore it has been differently worded by different authorities, though retaining the same concept and meaning of the mediation. And if we try to define mediation in my words, I would say mediation is a voluntary negotiation process where a neutral third party assists the parties in dispute to amicably resolve their dispute by using specialized communication and negotiation skills. So that's one way of defining it. The elements of mediation, if we think what are the elements of mediation? In detail, I am sure Shiv Kumar sir is going to enrich all of us on that. But according to my little understanding, elements of mediations are the components which constitute a complete framework of a mediation process. Therefore, some of the elements of mediations we can say are voluntary participation, neutrality and impartiality of the third party, self-determination of the parties, confidentiality of the process, competence of the mediator, and quality of the process. So all these elements and many other aspects of mediation shall now be explained in detail by a learned guest teacher, Shiv Kumar sir. So now it is over to you. You are welcome to address these students.
Thank you. Aditya, do you have anything to say before I take off?
Thank you so much, sir. Thank you. A warm welcome to everyone present here today. I hope you had a great week. And just before you take off and kick off your shoes and get into action to relax, I think this is the perfect way to end a fruitful week that we have. And we have Shiv sir here with us, fortunate enough to listen to the class that we'll have. My name is Aditya Vadva. I'm a fifth year student at NLI Bhopal, and I shall be the moderator for today. So I shall be responsible for taking in questions and helping you with any doubts that you may have, and I'll be giving those to Shiv sir. So I request everyone to kindly mention any questions that you may have at any point of time in the chat box, which then shall be posed to Shiv sir, either during the session or towards the end of it in the 30 minutes that are reserved for the same. If you wish to speak, then kindly mention the chat box and I shall unmute you so that you may ask your question. If there are any other doubts, kindly message me on this as well. And I think that's about it. So please, you may go through. Thank you so much.
Thank you. Good evening to everybody, all the young students who are hoping to be lawyers and thereafter, as a part of their law training, get into the mediation process. It's great to see so many young faces, and it encourages us to believe that mediation will take off in this country, and it is the future of dispute resolution. Just a couple of few observations that I would make before I actually get into the subject. The object of this exercise today of giving you some kind of input on mediation is not to make you mediators by this evening. That is not the object. That will take a lifelong experience to become a mediator. You are still on the threshold of a legal profession, getting into the academics. The intent, therefore, is not to make you mediators, but the intent is to give you a bird's eye view of what this mediation is about. There are people who confuse it with meditation. And therefore, it helps to be clear, to have a basic grounding and understanding of what the process is, what the components are. That is the object. So don't please look at this. Do not look at this and expect that by the end of 1.5 hours or 2 hours of this session, you are certified mediators. You will not. Let's be very clear about the result, the takeaway from this. The takeaway from this is a basic grounding, a basic knowledge of what mediation can be, what mediation is, and what mediation should be. All right. Second, the advantage of at the end of this session, what will happen is that you will probably have a head start over other law students who join law colleges. Therefore, you will not be at sea when you sit in a classroom and when your lecturer talks about mediation, your face will probably light up and you will succeed in making other students pretty jealous because you already have a basic knowledge of what mediation is about. That is the object, to give you a head start and nothing more than that. Please also remember that during the course of the next 2 hours, I am not going to give you anything profound. There is a general belief that the moment you say profound things, there is an inverse proportion to the knowledge you have. I do not believe in that. I will therefore restrict myself to sharing with you some simple thoughts. Try and keep it as simple as possible. Avoid all the profound statements that we find in various books and articles and so on and so forth. Why I am saying this is, even if these simple terms that I use are slightly unacceptable to you or ununderstandable by you in the context of mediation, please do not hesitate to interrupt at that moment of time and ask me whatever you wish to ask. That is why I am saying this. When we go through this whole presentation today, one of the things that all of you will have to necessarily keep in mind is the contrast between what we are going to discuss today and the existing court system. Learning by contrast is something very, very useful. So if you as lawyers are aware of what the court system is today, it will help during the course of the presentation to absorb whatever I share with you in the context of the court system, in the context of the existing court system. You will automatically be able to see the contrast. You'll be able to understand the principles of mediation far more easily than for me to constantly draw a comparison between the court system and the mediation process. And at the end of this session, I would love to hear from you why and if mediation should be the preferred mode of dispute resolution, which therefore means, translated into simple language, it means that you have to keep your eyes and ears and mind open during the course of the presentation. At the end of which, I would probably ask a couple of questions relating to the preferred mode of dispute resolution. And finally, before I begin, at Bangalore, we are experiencing power cuts off and on. Though I am in an apartment complex, it takes about 20-30 seconds for the generator to kick in. Please do not believe that because I have suddenly gone off screen, the class has not ended. The class will end only after the principal, Ma'am Pushgupta, says the class is over. We also have a class monitor today in Aditya. So it implies that the class monitor will take care of all the requirements of the class as the principal and the warden looks down on all of us in that position as a principal. Are we okay with that? Okay. As Aditya pointed out, questions are welcome during the presentation. I do not consider it as an interference at all. Please feel free to talk, to express your views contrary to what I'm saying, to discuss, to debate, to fight, to argue, whatever. I'm safe. There can be no physical assault on me because I'm away from you, but verbal aggression is permitted as long as it's within the four corners of the subject that we are discussing. Okay, let's begin now. I need permission to share the screen, please. All right. Okay. Could somebody tell me whether the screen is visible?
Yeah, okay.
Yes,
Yes,
Elizabeth.
Yes, Elizabeth, sir. Elizabeth.
Yes, sir.
Yes.
All right. Let's begin with the fundamentals. As was pointed out by Anup, he has defined mediation in a manner that he deems fit and appropriate. If you look at books on mediation, you will find as many definitions of mediation as there are people. In fact, contextually, depending upon the situation a mediator is situated in, the same mediator may have 3 different definitions of mediation. There is therefore no empirical definition of mediation for the simple reason that it is a process. It is not a thing. It is not an item. It's a process. Therefore, every person understands mediation in his or her own way and consequently defines it to suit his or her own perceptions of the mediation process. But we need not worry about definitions. It is not important. You can call it whatever you wish to call it. But the trick lies in absorbing the essence of mediation, in understanding how mediation works and what is mediation about. Mediation is therefore essentially a very innovative dispute resolution process. There have been enough references to section 789 of the CPC. Everybody who talks about or begins a lecture session or a training session in mediation begins with section 89. It's like the Hindu rites and rituals where you begin with Om. So the Om is equivalent to section 89 of the CPC. Ignore it. Please remember that it is an innovative process which has not been in existence for a long time in this country. Mediation has come into this country only in the year 2004, perhaps, or a little later. Therefore, let us be clear that it is an dispute resolution process. What is it based on? I think on the first class that you had, you probably were told that that mediation is all about perceptions. Now the question will arise, a dispute resolution process based on perceptions, how is it going to work? How does it actually work in day-to-day practice? A dispute is a dispute where there are 2 people fighting over something or the other. There is a disagreement about something. Now, how can a resolution be based on perceptions? Now, this is a catch-22 situation. But the fact of the matter is that because there are more than one perceptions possible in a given situation, a dispute arises. You may ask yourself the question, which comes first? Does a dispute come first or does a perception come first? That is again irrelevant. The fact that a single act or a single object or a single statement is capable of different perceptions by different people is the founding or the founding principle of the mediation process. Let us digress a little bit here. When we talk about the elements of mediation, that again is a definition which is capable of multiple interpretations. People call it fundamentals of mediation. People call it principles of mediation. It is called the jurisprudence of mediation. It is called the philosophy of mediation. It's called the pillars of mediation. Do not be misled by those terms. Terminology is not important. We have a habit of getting lost in words. Let us not worry about those words. Let us understand that all these words mean one and the same thing, namely the founding principles, the jurisprudence of mediation. What is mediation and what are the pillars or the founding principles on which this whole process rests? Therefore, we come back to the proposition that it is a dispute resolution process. Based on what? Based on perceptions. Your perception of a pen that I'm holding in my hand may be completely different from the perception of your friend. A comment that I make may be interpreted in multiple ways. The fact that it is capable of being interpreted in multiple ways results in a different perception of the same thing. To go back to the cliched example of half full glass or half an empty glass, that's the question of perception. And half a closed door is equal to half a open door. This is a very basic comparison, but please remember that everything in this world, including comments and conduct, are capable of multiple perceptions. And therefore, mediation recognizes that there could be different perceptions of the same thing, of the same conduct, of the same comment, of the same course of conduct, same response, of the same reaction. And it is founded on this fundamental principle. Second, the whole process of mediation is based upon dialogue and negotiations. It means we sit across the table and try to get every person in dispute to the same side of the table. So the principle of mediation, or the element of mediation, is the process tries to get everybody to the same side of the table. It is no longer a process where I say something and you say something. Mediation is based on the fundamental precept that if disputes have to be resolved, if conflict has to be resolved, it has to shift from I to we. And how does that to be achieved? It is to be achieved not by screaming your points of view across the table, but it is to be achieved by a process of civilized dialogue, a civilized conversation, rather than a monologue that most of us indulge in when we are propagating our respective perceptions to a third party. So it is a process which is based on dialogue. Once it is based on dialogue, it opens up the principle of negotiation. If you're willing to listen, if you're willing to absorb, if you are willing to consider that there could be two different viewpoints of the same situation, then you have opened the door for negotiation. Unless there is a willingness to open dialogue, the question of negotiation does not make any sense at all. Therefore, one of the elements of the mediation process is that it is something that is based on mutual dialogue, on a mutual acceptance of two contrarian views, two contradictory views, two possibly contradictory views, which we try to bring together, harmonize opposing views and opposing aspects of the same dispute. So in this context, probably, as Anu pointed out, it's a non-binding third neutral party intervention to facilitate a mutually beneficial settlement. As he pointed out, we do not have a statutory definition of mediation. Therefore, the Bible today that we follow is the AFCON's case, where the Supreme Court has defined judgment in its defined mediation in its wisdom. But it would be easy to understand the concept if you take the keywords from this definition. It's a non-binding process. It's a third neutral party intervention. It is not an interference. It is only an intervention. For what purpose? To facilitate a mutually beneficial settlement. This follows from the second principle that I have enumerated for you, namely dialogue and negotiations. The fact that we talk about dialogue means there are two people willing to talk to each other and willing to look at contrary perceptions. Therefore, it is a non-binding third neutral party's intervention to try and see whether we harmonize opposing needs and opposing demands. That is what a sense of mediation is all about. What are the kinds of mediation that we have today? We have court-annexed mediation. We have a pre-institution or pre-litigation mediation, and we have private mediations. We will not look at the private mediation because that is not in the realm of our discussion today. What we will need to look at is court-annexed and pre-institution mediation. Whether you like it or not, I have to go back to section 89 because court-annexed mediation arises from or takes its birth in section 89. There are several other provisions like the Consumer Protection Act, the Companies Act, which also refer to mediation during the process, a court proceeding or a proceeding before the authority is pending. They also become court-annexed mediation. It simply means that whenever there is a proceeding pending in a court or a statutory authority or a tribunal, and that particular case or issue is referred to the mediation process, it is generally termed as court-annexed mediation. Sometimes it is also referred to as court-monitored mediation. So the source or one route by which cases get referred to the mediation process is through the courts, which means for mediation to commence in court cases, a court proceeding is essential. That is the sine qua non of court-annexed mediation. Now, under the Commercial Courts Act, you have pre-institution mediation. It has created a situation where even before you enter a court of law, seeking to enforce your right, contractual or otherwise, you necessarily, mandatorily have to go through a pre-institution mediation process. This works extremely well in the United States, where we are informed that over 90% of the cases are resolved before they reach the court because of pre-institution mediation. The pre-institution mediation is conducted and controlled by the Legal Services Authority, and there is a whole process that is prescribed by which the intending plaintiff has to approach the Legal Services Authority, follow a certain prescribed procedure. There is a panel of mediators who have been appointed who go through the process of mediation, and then if it does not succeed, they are entitled to go to a court of law. Now, irrespective of whether it is court-annexed mediation or pre-institution mediation, the process of mediation remains the same. The elements of mediation, the jurisprudence of mediation, the principles of mediation all remain the same. There is no change in the mediation structure or the content or the process or the procedure. It is just that one happens, court-annexed happens once the court refers the case to mediation. Pre-institution happens before you enter the court. Now, the important thing to note is if pre-institution mediation has failed, that is, if the plaintiff has not succeeded in resolving the dispute before you enter the court under the Commercial Courts Act and the case has been filed, it does not prevent the court from once again referring the matter to mediation under the heading of court-annexed mediation. So you can have pre-institution, thereafter court-annexed. They are not mutually exclusive. It does not mean that there is estoppel. You can keep trying mediation until the entire dispute has been resolved. So these are the kinds of mediation. Private mediation, as I said, we will keep out of the picture, but you should be aware that both pre-institution mediation is happening in the private sector, in the private space, and otherwise. Right. The next question, therefore, before we get into the cream of it, who is a mediator? I will define it for you by the process of exclusion. There are two ways of defining anything. One is by exclusion, one is by inclusion. I have adopted the exclusion process, which means mediator is not a judge, I'm not a counselor, I'm not an advisor, I'm not a conscience keeper, I'm not an instrument of social change. So what am I? Am I a fool? Maybe, but I'm an intelligent fool. An intelligent fool who's capable by my training to facilitate a process of dispute resolution. That's all I am. What does it mean? If I say that I'm not a judge, a mediator is not entitled to deliver judgments. He's not entitled to decide an issue. I'm not a counselor, therefore I'm not entitled to give you advice. I'm not entitled to pass comments on what you've done, to value judgments on what you've done. I'm not allowed to do that because I'm not a counselor. I'm not an advisor. I cannot give the parties legal advice, nor can I give them emotional advice, nor can I give them general advice as to what should be done and what should not be done. I'm not a conscience keeper. In the sense, a mediator is not allowed to say, why don't you fight for women's rights? Why are you allowing you to be trampled over by your brother or your sister or somebody? I do not decide on or pass judgments or determine what is morally right, what is morally wrong, what is ethically right, and what is ethically wrong. That's not a part of the mediation process at all. And that's one of the fundamental tenets of the mediation process. One of the principal elements of mediation process is that I am not any of these, nor am I an instrument of social change. By the process of mediation, I do not have the power or the authority to see that society changes in its concepts that it is living by. Therefore, it leads inevitably to the conclusion that I'm only a facilitator. And what I mean by a facilitator is I'm a catalyst. The mediator is a catalyst who understands the needs and the requirements of both the parties, understands the contrary motivation for a dispute between both the parties, is able to get to the essence of the matter, is able to get to the essence of the dispute, find out what is it that is causing the dispute, prioritize the issues, understand what kind of relief the parties are looking for, harmoniously blend the opposing needs of two or more parties, and help them to come to a conclusion if possible. So, all I do as a facilitator is to encourage them to get into a dialogue process. Please understand why a facilitator is important is people who are in conflict, it is impossible for them to have a rational approach to a problem because every conduct of theirs, everything that they say and do is guided on the platform of conflict. Therefore, a facilitator helps them to separate those issues, helps them to understand the actual issues. And to that extent, I only facilitate and I do not do any of these things. Right. Now, what are the first principles and elements of mediation? It is not based on authority or power. As I said earlier, if you contrast this with a court of law, a judge has authority, which is vested in him by statute. And by virtue of that authority, exercises power. These are the twin principles of the principles. And what do we mean by authority and what do we mean by power? A court of law, for example, has the authority and the power to make you do something that you don't want to do. Conversely, it can prevent you from doing what you want to do. You may want to encroach upon your neighbor's property and build your wall 6 inches into his property. You may want to do it. The court has the power to prevent you from doing it. Conversely, you may not want to do something, but the court can compel you to do something. You may have already built a wall on his property. You may not want to remove it, but the court has that power born out of that authority, statutorily vested in it, to compel you to remove that wall. These are the twin principles of authority and power. A court is vested with it. The principle of mediation is that a mediator has neither the authority nor the power to compel you to do anything. A mediator cannot say, you shall do something. It is not in his competence or power to say, you shall not do something. Therefore, the next question arises, what is a mediator all about then? If I do not have the power to compel the parties to do something or to prevent something, how does a dispute get resolved is the question that probably arises in your mind. We will answer that as we go along. So first principle, it is not based on authority or power. Second, mediation is not an adversarial process. If you are familiar with the court process, you will recognize and understand that every proceeding in a court of law is an adversarial process. And by adversarial, I mean that I stand in front of you and take an opposing stand to fight you. An adversarial stand is born out of legal statutory rights and enforcement of those rights. The moment we begin to enforce our rights, claim our rights, we are already in an adversarial position to the person who denies those rights to us. That is adversarial. And once it is an adversarial process, necessarily the justice delivery system or the court system has to focus on right or wrong. What is a right ultimately? A right is an entitlement. When somebody denies that right, it becomes an infringement of that right. If under the law I have a right, then the focus has to be in the justice delivery system. The focus has to be on upholding my right, on vindicating my right. But if I have no right, then the question of vindicating that right does not arise. These two propositions, namely that one is non-adversarial and there is therefore no focus on right and wrong, are the elements of mediation. Mediation is not an adversarial process. Mediation does not believe in looking at right or wrong. In fact, mediation is not even concerned with what is right and what is wrong. Mediation begins to treat both parties on an equal platform. It does not recognize the fact that you are on opposing sides of the table. It does not focus on rights. There is no adversarial stance in the mediation process. It applies Article 14 that all of you are equal. We will treat you equally. You are not opposing each other. Mediation puts that aside. Mediation does not look at law. Mediation does not say, let us see who is right and who is wrong. Therefore, the focus shifts from right and wrong to solution. Mediation says it doesn't matter to me who is right, who is wrong. What I'm concerned about is how do we find a solution to an existing problem? Aditya, do you have any questions so far on chat?
Nothing so far, sir.
Very good. Okay. No, not very good, but all right, we'll accept that. Okay. Well, the next principle or the element of mediation is that it is a party-centric process in contrast to the court system. Those of you who have witnessed court proceedings, not in Hindi movies, please, that is not the standard. That is not a court proceeding. So don't go back to the Hindi movie style and imagine that is how the courts work. That's not how the courts work. But you have some idea of how the court processes work. You will realize that the litigants are the last persons who can be claimed to be important in that process. The judges of prime importance, the system of the next importance, the lawyers are of the next importance, and finally the parties, or actually the litigants, are last or least in the order of priority. The importance there is not to the parties. By parties, I mean the litigants or disputants in the mediation process. Now contrast this with the mediation. Mediation believes as a fundamental element of the process that it is a party-driven process. The important people in a mediation are the disputants and not anybody else. It is the parties who enjoy the authority. It is the parties or the disputants who have the power to decide what Anup called self-determination. The parties have the right and the power to decide whether I will participate in the mediation process, how long I will participate in the mediation process, and decide whether I should decide or not. So the whole focus of the mediation process is on the parties rather than on anybody else. That is one of the fundamental elements of mediation. The moment the focus in a mediation process shifts from the parties either to the system or to right and wrong or to statutory rights or to the mediator himself, then the whole process of mediation is derailed and the elements of mediation have been completely vitiated. Elements of mediation sex is self-determination. What exactly do we mean by self-determination? We mean that the disputants retain absolute control over the decision to settle and the terms. Now, please contrast this, as I said, with the court process. Who determines the decision? It's a judge. After necessary material has been placed before a judge, and after all your lawyers have exhausted their best persuasive powers in the process of argument, it is a third party, namely a judge, who determines what is right, what is wrong, what is good, what is not good, and determines what should be the manner in which this dispute should be settled. The power of the parties to determine whether they should settle this dispute, and if so, on what terms, is taken away from the parties and vested in a judge. Now, in mediation, that is not the case. The right of the parties to a dispute, the disputants to a parties to determine for themselves how and what shall I do is what is one of the fundamentals of the mediation process. And why is it important? It is important because the disputants are the people who are in conflict. Therefore, they are the ones who are most concerned about it. And therefore, they are best suited to feel happy or
दीजिए दूध
sad.
रुको चुर रहा है दूध अभी
Sorry, what was that? There was an interview. What was that? Hey, Aditya, what was that? I heard some conversation. All right, okay. So self-determination is one of the elements of the mediation process. Then we come to the most important, Aditya, do we have any questions so far?
Not yet, sir. Not yet.
Not yet, okay. Remember that mediation is a voluntary process. What do we mean by voluntary? What are the dimensions? A mediation process recognizes the unconditional right of the disputants to participate in the process or not participate in the process. Now, if you read one of the writings that are articles that have appeared in the e-mediation writings, you will realize that there are two concepts or two dimensions to this. One is called the opt-in process. The other is called the opt-out process. After the judgment of the Supreme Court in Afcon's case, and certain other legal provisions in the Consumer Protection Act and in the Companies Act and so on, it appears that the resorting to the mediation process may have become mandatory. It is possible for the courts to compel a disputants or the plaintiff and the defendants to go through the mediation process or to refer the case to the mediation process. Therefore, the question that arises is it really a voluntary process? The middle path which has been taken globally is that the requirement of trying to resolve a dispute through the voluntary process does not violate any principle of voluntariness. But having come to the mediation table, there is no way any process of law can compel a disputant to actively participate in the mediation process. A classic example of taking the horse to the water but cannot make it drink. You can send me to the mediation room and say that you will attend the mediation process. Excellent, I will attend it. But there is no way you can compel a party to actually participate, to continue participation, and actually to settle the matter. That is still remains in the realm of voluntariness. Therefore, translated into simple language, it means once a disputant has entered the mediation process, it is open to either of the disputants or both the disputants to walk away from the mediation process, to terminate the mediation process. And the beauty of it is there is no reason that need be attributed for withdrawal. That is how we empower, mediation empowers the parties. And that is one of the elements of the mediation process. If you do walk away from a case in a court of law, there are certain penal consequences that flow. You may have an ex parte decree on your hands, or your suit that you have filed may be dismissed. There is some consequence that flows. But in mediation, being a voluntary process, even if the disputants walk away without giving any reason, there is no penal consequence that flows. You can still pursue your remedy in a court of law. Conversely put, by virtue of the fact that the parties have the right to walk away from the mediation process, the mediator is not vested with any authority to ask why you are walking away. In other words, the parties or the disputants are not accountable to the mediator. The mediator has no authority to insist or compel them to participate in the process. This is one of the most fundamental elements of the mediation process. It gives an opportunity to the parties to be secure, feel secure and happy that there is no element of compulsion here. I can participate as long as I want to. I can leave when I want to, without any penal consequences that will follow. Mediation, one of the elements of mediation is that it identifies conflict and dispute. I'm sure this would have been covered when Mr. Javed spoke about it.
Yes, sir.
Sorry?
Before you move on to the next point, there was a question from this part. It's from Shambhavi, who asks, if the parties start the process of mediation, but their differences are not solved, does that fail the mediation process? And the second question is the legal proceeding the only way left?
Okay. Let me try and answer that as briefly as possible. Mediation, one of the principles of mediation, the philosophy of mediation is that there is no failed mediation. The concept of a failed mediation does not arise in mediation. Now, you may ask me, why? How do you establish, how do you prove that point? It is proved or established in this manner. The object of mediation is not only resolution of disputes. The object of resolution is multifarious, is a multitude of objects that we achieve. What are they? Resolution of dispute, bringing the parties together face to face, encouraging communications between or amongst the parties, opening up channels of communication between the parties, giving them an opportunity to understand each other's perspective, giving them an opportunity to understand the emotional quotient of each other, understand the real need of each other, and most important, giving them an opportunity to understand that apart from a court of law, there are other options open for you to resolve the dispute. Let us remember that having been stuck with the adversarial system of a justice delivery system for centuries together, the moment there is a dispute, the first option that occurs in the mind of people is a court of law. I mean, it's like saying, if you think of some religious ceremony, priest. If I think of hunger, food. Saturday evening, scotch. There are associations. Therefore, when you say dispute, it's a court. Mediation tries to explain and open up the possibilities and make them alive to the possibility that dispute resolution is not necessarily only through the process of adversarial relationships. Therefore, even though a mediation may not result in a settlement of the dispute that has been referred to mediation, it opens in their minds a variety of thought processes which gets them to think about what they are doing, why they are doing, how they are doing, and why they're doing what they're doing. So if you look at it in that larger perspective, if you look at it in those parameters, there is no failed mediation at all. The belief that a mediation is successful only if it results in a settlement is therefore a non-acceptable proposition to us. That is, have I answered the question? Would you find out from her if that answers the question?
Shambhavi, kindly, I think just reply on chat, or maybe you could unmute yourself if you have any.
Unmute yourself. That answer your question?
You have. She just answered.
All right, great.
So
second question.
question.
Second part of that question, is therefore the court the only option? No, it's not. Just because you have participated once in a mediation process which has resulted in a non-settlement does not debar you or stop you from going through the process all over again. The contrast is between a court and other forms of dispute resolution. Consensual process of dispute resolution, which means you can go through mediation, you can go through conciliation, you can go through arbitration, you can go through family counseling, whatever you want, all within the legal framework. But what it does bar is supari contracts. Those kinds of dispute resolution is prohibited. But within the legal framework, just because a mediation has not resulted in a settlement, it does not mean that you debars you or stops you from going through either the same process or other process of law. Is that okay?
Right.
Shambhavi, is that okay?
Yes, sir. She's written.
Right.
Thank you so much.
What's the next question?
I had a question of my own, sir, which was basically from the point of view of the mediator. Now, considering that parties are free to walk off anytime they want, how do you ensure that what they have talked about, has some say in the court of law? Now, I'd like to just propose two things here. The first would be if there's a main issue involved and there are, say, certain sub issues maybe that the parties have agreed upon. Do you go to a deed every time a session is concluded to ensure that parties are on the same page and like they sign a legally enforceable document? And the second was, sir, that the parties are speaking to each other and there are certain facts that have been accepted from either side of it. Which basically means that there is a narrative that has been accepted by both parties, which later they may refuse in court. So can the mediator say enforce something, maybe get them to sign something that agrees that this has happened and you've accepted about something like that?
I'll come to that part of it, which comes within the realm of confidentiality. Probably the next slide or so will take care of the second answer. The first answer, whether there could be a partial settlement, yes, it is possible. If there are four, we don't talk about issues in mediation at all. We talk about perceptions and concerns. So the terminology is very, very important to us. We don't say issues. Issues relate to court. We talk about, what do we talk about? We talk about how do we resolve a dispute, or how do we resolve a perception? What are the points that concern you? What is it that concerns you? Whatever that be, however you word it. If there are four subjects to be discussed and resolved, and two are resolved, there can be a partial settlement, and the other two can go back to the court for resolution. That is permissible in law and in the mediation process. Okay, the second question I will answer for you when we get to the confidentiality stage. Okay, all right. Now you have, why is this line coming in between? Was I responsible for it?
No, sir. I think that someone else has done it. If
someone else has done it.
Unfortunately, I can't remove it, sir. If I
okay, doesn't matter. It doesn't matter.
Just get your cursor up to the share screen bar. You'll be able to remove. There'll be a option to remove any markings.
Where, yeah, forget it. It's okay.
Okay, sir. No.
I'm not tech savvy. This is all I can do. Okay. Now, Aditya, were you present at the first class? You were. Was this concept of conflict and dispute discussed?
Yes, sir. We had an introduction to both of these.
All right. So if you are aware of it, then I will not spend time on it. The elements of mediation is that mediation jurisprudence defines conflict and dispute. And the best way to describe it is that you take the example of the difference between allopathy and homeopathy. If you were to go to an allopathic doctor for a headache or a stomach ache, he would probably give you a crocin or a dolo and say, this is it, please take it, it's symptomatic treatment. Whereas you go to a homeopathy, he will ask you 2,000 and odd questions, look at your toes and get to the root of the matter. Therefore, mediation, elements of mediation, principles of mediation, jurisprudence of mediation believes that a dispute is a manifestation of a conflict. A conflict is the root. From the root, multiple perceptions arise. From those perceptions, multiple disputes arise. Mediation looks at resolution of conflict rather than of dispute, because a dispute can be resolved by a court of law based on rights and wrongs. But in mediation, if we resolve only the dispute, the root of it, the root cause of it, the moola, the root remains, which could possibly result in other conflicts or disputes at a later point of time. Therefore, mediation principles define conflict and dispute as two different entities and record that dispute is a result of conflict and not otherwise. Okay. We also distinguish interest from positions. This is a very interesting concept. Please tell me if this has also been covered by Mr. Javed. Aditya?
Yes, sir. I think we did discuss interest and positions.
Yes. Not covered, sir. Not covered. Not
covered. It was just mentioned. That's what
is not covered.
All right. Now, this is a very interesting thing. Interest and position, one of the principles of mediation is that mediation looks at interest as being different from position. What is a position? A position is a stand that I take based fundamentally on law, based fundamentally and arising out of statutory provisions in law. Naturally, therefore, it veers towards rights, my statutory rights, my contractual rights, my fundamental rights, etc., etc. Therefore, when a party goes to a court of law and says, this is my right which has been violated, I want my right to be restored, it is a position that he is taking, that I want this because it is my right. Now, what mediation does is to go behind that position, to keep understanding by conversation and dialogue, why is it that this is bothering him? What is it that he actually wants? Is it that he wants this specific right to be enforced? Or is there something else behind it? What is the motivating factor? It distinguishes need from want. I may want to be the Prime Minister of India, but what is my need? It may be different. My need may be that by virtue of the power that vests in me as the Prime Minister of India, I will give myself a good house and I will see that I do get 4 meals a day. The position is that I want to be the Prime Minister, but the interest is I want my stomach to be full and my bar counter to be full. Let me give you another example. This is a live case that happened. There is two of you are very good friends. You have known each other for the last 50, 60 years. You have lived peacefully. One of you has a coconut tree growing in your compound, which is tilting towards the other's compound. As a result of the tilt of the coconut tree, coconuts are falling into your compound and destroying your pots, destroying the car and creating dents in the car and so on and so forth. But you are such good friends that you have just kept asking your neighbor, why don't you set this right? Why don't you set this right? Something he probably takes you for granted, and this is not remedied. What do? You approach a lawyer and file a suit for an injunction, restraining him for a mandatory injunction, asking him to cut the tree. Now, the position that you have taken in a court of law is that I'm entitled to protect my property from interference by somebody. Therefore, I'm entitled to have that tree cut. That is the legal position you have taken. Now, what is that the court can do? The court can decide whether that tree should be cut or not be cut, whether your right should be vindicated or not be vindicated. But what does mediation do? The principles of mediation says, come guys, come sit. Let me understand what is it that is bothering you. Now, in the process of mediation, it transpires that I do not want the tree to be cut down. That's not the interest. What is my interest? My interest is to protect my property and my car from destruction. That is the focus. Whether I have a legal right or is not the focus. The focus is I want my property to be protected. That is the interest and position. Therefore, in mediation, what do? We try and find solutions outside of the law. And in this case, the solution was that we would put a steel structure at the cost of the neighbor so that the coconuts, even if they fell, did not reach the ground. Now, when we talk about positions, the court is not authorized, does not have the power because it functions under the 4 corners of the statute. It does not have the power to grant that kind of relief because it is not equipped to understand only that interest. Mediation, therefore, says, I will focus on interest rather than in positions of law. And therefore, I will find a solution which protects what you actually need versus what you're demanding. Demand versus need, want versus need. Principles of mediation say we will focus on need rather than on. Okay? Right. Elements of mediation, one more very, very fundamental concept of mediation, we do not apportion blame. Mediation does not apportion blame. In a court of law, in any other justice delivery system, including arbitration, you will necessarily have to apportion blame either on the plaintiff or the respondent or the petitioner or the respondent. Because unless you apportion blame, you cannot grant relief. You have to vindicate a right or refuse the right. Now, mediation does not focus on it. The element is we do not worry about who's right, who is wrong. It does not bother us at all. We focus on solutions. That is one of the fundamental concepts of the mediation process. Mediation steers clear of moral and value judgments. the temptation for a mediator to pass value judgments within himself or herself is very, very strong. But mediation teaches you, do not judge people. Understand people as they are. In fact, one of the the very succinct way that I put it is to say, mediation understands that this also is, rather than this ought to be. Courts focus on this ought to be. Mediation focuses on this also is. So under that umbrella of that principle, there is a wide range of concepts that come in. And one of the most important concepts is that we steer clear of moral and value judgments. Because the moment you pass a moral and value judgment, the mediator passes it, mediation converts itself into a judicial process. We also have one of the principles is confidentiality. What do we mean by confidentiality? It means that all the states, almost all the states in India have framed rules for in the matter of mediation, which says that no courts in India will be allowed to call the mediator as a witness to testify as to what went on in the mediation process. So you're protected. That gives opportunity to the parties to say what they wish, to be transparent, to be open, to maybe even admit liability. Because the mediator can never be called as a witness in a court of law to testify as to what went on. It also therefore means that either of the parties are not allowed to use whatever is said in the mediation process in a court of law. And to answer the question of Aditya, suppose in a mediation process, the defendant says, yes, I owe him 10 crores. I admit it, but I am not going to pay it. An open admission of liability of this kind is not admissible in a court of law as evidence because it is protected by confidentiality in the mediation process itself. There are two kinds of confidentiality we talk about. One is called the process confidentiality, which means whatever transpires here, the process is protected by law, by rules. The other is called caucus, that is sessions. Whatever is said by the parties in the session privately is also protected. So this blanket of confidentiality is an overarching architecture. There is no way that anything that is said in the mediation process is going to be leaked out. Now, when we are doing online mediation, we have had these issues because apparently recording facilities are available, either on screen or on your phone or whatever other device. Therefore, we request parties in online mediation to ensure that there no recording takes place. However, assuming that a recording does happen, it is not admissible in evidence in a court of law because it occurred during the mediation process. So that gives you complete confidentiality. You will not find this in any other proceeding, including arbitration. This gives the opportunity for the parties to feel a sense of security, feel a sense of being honest in what they desire. Link this to the previous one, interest and position. It encourages the disputants to actually state what is their actual need and what is their actual demand that they are making. It assists them in doing so. Then we come to neutrality and impartiality. This is very simple. Neutrality simply means that I belong to neither of the parties. We have quite often raised the question in my trainings whether neutrality and impartiality mean one and the same thing. Now, that is a question for you to decide. That takes a long time. But the viewpoint that I take is that neutrality and impartiality are two different things. And what mediation needs is both. If I belong to one party, I can still be impartial. But if I don't belong to either party, I can still be partial. So neutrality relates to the person concerned. Impartiality relates to the conduct of that person. One is not exclusive of the other. It is not mutually exclusive. Mediation, therefore, harps on the principle, survives on the principle that you will be both neutral and impartial. Now let's go back to the first principle of power empowerment of the parties. The moment a disputant feels that the neutrality has been compromised, or that the mediator is leaning towards a particular party or a particular disputant, mediation empowers that party to withdraw from mediation or ask for the appointment of another mediator. So this principle of likelihood of bias is the same principle that applies here. Then there is finality and certainty. The legal proceedings is famous for steps of appeal and lasting 10 years to 15 years because it provides a graded scale of appeals and so on and so forth. But the fundamentals of mediation says that if you sign a settlement in the mediation process, it is final and it brings an end to the litigation that you're fighting. There is certainty to it. Finality is one aspect of it, certainty is the other aspect. Every dispute in a justice delivery system in the court of law is riddled with uncertainty. You do not have any clue as to what the judge will say, how the judgment will be delivered. You have no clue as to what the appellate court will say or how it will view it. You still have no clue as to what the highest court of the land will say. Therefore, these twin principles that all disputes will finally come to an end when you sign a settlement, because a settlement is signed by consensus, by your understanding how you would want the dispute to be settled, and by the exercise of the self-determinative power that you've got, there can be no appeal or no uncertainty about the appeal. So you have therefore finality and uncertainty as a part of it. Mediation focuses on resolution rather than on settlement and compromise. All of us have some time or the other told many of our friends, hey, come on, go and settle this, man. Hey, come on, settle this, compromise. These two words, settlement and compromise, have necessarily inbuilt into them, inherently inbuilt into them, a certain element of giving up something involuntarily, being compelled to give up something in the larger interest of resolution. But mediation specifically looks at resolution, which means it's a voluntarily accepted terms of settlement. We look at resolution, which changes the focus. It changes the focus of the parties. It changes the way parties look at the mediation process. It preserves and is without prejudice to legal remedies. The elements of mediation tells you that just because you participate here doesn't take away your legal rights. You are free to go back to the court and fight your remedy. It offers opportunity for creative solutions. You remember we talked about that leaning coconut tree. That was a creative solution. No other system offers it. And the beauty of the mediation process or the principles of mediation says we think out of the box. We think creatively and see how solutions can be found. It views conflict from the human perspective and recognizes the validity of emotions. Therefore, mediation is a human process. It deals with human beings and human emotions, not with rights, not with statute, not with law, not with impersonal behavior. It recognizes that you are a human being, and therefore you would have wants, needs, desires, perspectives, views. Mediation gives you a wide range of opportunity to put those elements on record and see how to find a solution. And remember that mediation is not circumscribed by legal technicalities and procedures. We are not bound by sections and provisos and subsections and sections of law and act and law of evidence. In fact, the rules that have been framed for mediation say that the mediator shall not be bound by the rules of evidence at all. Unlike in a court of law, where for everything you are bound by procedure and technicalities, mediation ensures that there is no requirement of those procedures. Therefore, these are the principles. And the final principle is that unlike in a court of law where there is a loser and a winner, where there is a happy party and an unhappy party, mediation recognizes or functions under the principle of win-win. That is, both parties are equally happy. Both both parties get what they want. Disputants get what they want. Why do they get what they want? They get it because they decide what they are happy with. The judge does not decide what you're happy with. You decide what you want and what you're happy with. So if I'm happy to give up 50% of my monetary claim against you and go home saying, wow, this is fantastic, and the opposite party goes back saying, wow, man, I've been given this great concession of 50%, both go back happy. Rather than having a decree in your hand and saying that, look, I won and I lost. There is something going on here. If somebody is, okay. All right, now let me get back to stop sharing the screen. This is generally a very, very basic bird's eye view of what the mediation principles are. Now, these principles do not operate in isolation. It's a combination. These principles have to be translated into individual skills. So success of mediation does not depend on these principles. It depends on how you as a mediator implement these skills. That is the important point. When I say confidentiality, it depends on how I convey to the parties that what you say here will be protected by confidentiality. So let us not mistake principles for skill. Principles is only the theory, like the theory of law, like the theory of Raoul's theory of the legal justice system. That's theory, very good. You have theory of how to make a dosa, how to make a burger. Excellent, you have recipes. You must be perfect theorist. You may say 100 grams of this, 20 grams of this, 5 grams of this, but the skill is in making it. Nah? Ultimately, implementation is where your capacity is proved. Therefore, separate these two. Skills, theory. Theory tells you what should be done, what cannot be done, and what can be done. How it can be done, skill. That can be taught only by on-hands experience. So I will stop here for the moment. I think I've exceeded my time by close to 12 minutes. But then those 12 minutes have been taken by Anup in introduction and Aditya by my introduction. So I have no issues in extending it. Please let me have questions. There is some questions. Any question?
Yes, sir, there are. Nikunja,
are you putting me on chat? Okay.
Yes, it's on chat only. Nikunja has asked that in case of pre-institution mediation, who will appoint the mediator?
Good question. Very, very nice question. Who is this?
Nikunja Kumar.
Nikunja Kumar Sharma. Are you on screen?
Yes, sir.
Where? I don't see you. Where are you? Anyway. Okay, doesn't matter. All right. No, Anup has come on screen. Okay.
No, he's also there, sir.
You are the one. Okay. This is a very troublesome question. Technically, in court-annexed mediation and in all other mediation, private mediations, the parties have a choice of a mediator. They are entitled to choose mediators, which empowers them also to select subject mediators if necessary. For example, if a mediator is not familiar with IPR law or with trademark law or with finance law or with commercial law, but is only familiar with either civil law or injunction law or family law, posting or asking that mediator to function as a subject specialist in a commercial mediation is actually derailing the mediation process. So theoretically, parties do have a right to choose their mediator. Unfortunately, insofar as pre-litigation mediation under the Commercial Courts Act is concerned, the Legal Services Authority maintains a panel, and they reserve the right to allot it to the mediator. Now, I am not in agreement with this process, but there's nothing I can do about it. But that is the process. But it also gives the same right to the parties to tell the Legal Services Authority, I do not want this person, I want a subject specialist. That is permissible in law. But in private mediation, which is neither court-annexed mediation or pre-litigation under the Commercial Courts Act, both the parties can agree to anybody. So there is a slight problem there. Then,
Right, thank
anything
you.
else?
Yes, sir,
Anything
there
else?
are. I think, sir, just before I take up that question, it's a request to everyone to kindly put in any question that you may have right now. Since we don't have a lot of time right now, we may not be able to take every question that is popped up. And I'd love it if I just compile the list and then send it to sir as soon as possible. And he may
We
reply
do.
in a day or two.
No, Aditya, we have time. We have at least 15 minutes. Let them
No,
show
no.
themselves. Let them show
Right.
themselves and ask the question. I encourage that oral. This
Yes,
writing
sir.
business is running away from speaking. I want to
So,
hear somebody.
so you could have actually asked for anything else, it would have been possible, because Nikita right here just wrote to me that she wants to switch on a mic to ask you a question.
Please go ahead. Who
And
wants to
yeah,
switch on? Who?
Nikita, please go ahead.
Good
Where is
evening.
Nikita? Where is Nikita? Oh, you are Nikita. Okay, please go ahead.
So I have two questions. The first
Okay.
question is with respect to self-determination. Since India as a society,
Your audio is breaking.
one second.
Yeah,
Is it
go
better
ahead.
now?
Yeah, go ahead.
Yes, go ahead.
Yeah. So with respect to self-determination, since about like determining what is best for me according to my interests, India as a country being so divided in terms of hierarchies and identities, there are several who are quite vulnerable and probably unable to really voice their interests as such, which is why they probably rely on lawyers, as experts to voice their voice probably better than they can. So in such a case, will vulnerable parties, who probably don't really know their rights themselves, really seek any concrete remedy as such in such a case? Second thing,
So let me answer that first question. Let me answer that question before you go to the next question. My age, sometimes the second question goes away somewhere. Okay, you are talking of a situation where, by the very nature of the parties, the cultural issues in India, the kind of society that we have in India, the hierarchical society we have got, the power systems in India, your apprehension is that it may not be possible for some of the parties to actually voice their interests. Okay, let me clarify that. No party in mediation comes with a clear idea of what their interest is. Nobody, including the biggest and the most educated. They come with demands. They come with positions, which they are very clear about, either because the council has coached them, or because they have read it somewhere, or their family members have coached them, but they are extremely clear about the demands that have been made, because it's in the plaint, it's in the court documents. They will not voice their interest because they don't know what the interest is. And there lies the skill of the mediator, through the training process that we learn how to draw that out from them. There are communication skills, there are questioning skills, there is a requirement of creating a cordial environment, a pleasant environment, creating confidence in the mediator, creating a happy relationship on a one-to-one relationship with the person, and draw it out. Now, the difference is this. When you prick yourself with a needle, the blood automatically comes out whether you like it or not. But when you have to draw blood for a test, there is a methodology in doing it, right? It doesn't go all over. Same analogy you take to mediation. The skill of a mediator is to draw this information. Is that a fair answer for your question?
yes, sir. Yes.
All right. What is the second question?
Second question is, say there is a mediation that has probably maybe like something with respect to the environment, the final settlement probably harming the environment, for instance. Such cases being not really determined by any moral principles or environmental law principles, etc., will such settlements be overruled or anything of that sort? Based on like utilitarianism for that.
Now, you are talking of a different kind of mediation. You're probably talking of community mediations and public issues that are involved. Environment arises when? if there are two people who are fighting on environment and the dispute is individual to both of them, it certainly can be resolved. But if you are talking of a larger perspective of, let's say, air pollution in the city of Bangalore, now that dispute, for example, will never be referred to the mediation process because the large public is not represented in the mediation process. The very nature of public interest litigation is that there is no liss, there is no dispute. Remember that. So that probably will never be referred. Even the Babri Masjid case, there was a dispute, which is why it was referred. But if there is a neighbor who has started a factory in a residential accommodation, and the neighbor says there is smoke coming out from here, which is environmentally bad, not for the public, but for me, because the smoke is coming into my house, yes, that certainly can be resolved. And setting aside a settlement which has been voluntarily entered into by the parties is not possible unless the same grounds that are applicable to challenging a contract are applied. Namely, it was done by force, or it was done by under compulsion, or that the mediator forced me to sign this settlement. Only on grounds of those grounds, a settlement may be set aside. Otherwise, it's a voluntary settlement. So public issues, no. Private issues, yes. Does that answer your question?
Yes, sir. Thank you.
All right. Anything else? We had some question. It was in the box. What was that? I have another question.
There's one more question. Oh, please go ahead.
Go ahead. I want to hear you speak. Go ahead.
No, so it's just that the question is that is there any possibility of bias at the time of choosing the mediator?
Who is this again? Oh, again.
Nikunja Kumar.
Bias of whom? Whose bias? I'll counter that question with a question. Whose bias? You are muted. Anupji, you are muted.
I think probably he's talking about the bias of the mediator to one of the parties. Probably let Nikunj clarify this.
Yeah, where is Nikunja Kumar? Where is he?
Why don't you clarify what you are trying to ask?
But where is he?
Sir, can you see him now?
No. Let me attach a face to the name. That's what I'm to do. Yes, I've seen now. Yes, Nikunj, tell me.
I've requested to unmute him as well, but
yeah, you have to unmute yourself, Nikunj. Please unmute yourself. Unable to unmute.
Yeah, Hankinson, sir, can you please?
Okay. If you're talking of the appointment of a mediator by the Legal Services Authority, I do not think there could be any bias because they don't know the X from Y or Y from Z. But if there is a feeling you get that there is bias in appointment, you have an unconditional right to ask for a change. That right is vested in you, and assuming that there is a bias in the appointment, you can always say, I don't want this mediator, I want some other mediator. But generally it does not happen because none of the parties to the mediation or disputants know who is allotting to whom. There is no interconnection or knowledge of the parties. Have I answered your question, Nikunja? Please tell me on your chat. Unable to unmute.
I think that's the last one. I've asked.
Unless Nikunja is saying that there could be a dispute between the disputants as to who should be the mediator. That is possible. One of the parties may insist that Mr. X be appointed because he knows Mr. X. And Y may say that I want somebody else to be appointed because I know Y. That is their individual bias. But the actual allotment, which is done by an institution, by the Legal Services Authority or the mediation centers, are generally not in the realm of bias. Okay.
So we have Michael who wishes to ask a question.
Sure.
I'm just going to unmute you as well. Yeah.
Who?
Yes, Aditya. Good evening, sir. My name is Michael, sir.
Yeah.
Sir, So how long does a mediation last, sir? What is the time frame?
Good question. Mediation technically, theoretically is 60 days within which you have to resolve the dispute, extendable by 30 days. That's the maximum period. And in court annexed mediation, if you do not resolve it within that specified period, the mediator is expected to send the case back to the court. But it does not prevent the court from sending it back again and saying you get another 60 days. Why this 60 days has been prescribed is the process of mediation began to be misused. I don't know whether you've heard of the term bench hunting in a court. Bench hunting means I know this judge. I know he is favorable to me. Therefore, I would much rather that my case go before that judge because the other judge is very strict. So they began to use mediation to get away from that judge and keep it here for months together. And then once the judge changes, send it back to the court. Therefore, the law said 60 days is maximum. Exceptional circumstances, you can extend it by another 30 days. That beyond that, it has to go back.
So Nikita has a question, and after that we have George.
Sure. Yes, Nikita.
Just following up.
Go ahead.
Yeah, just following up on the factory example. Say the settlement reached is beneficial to both the parties, but diverts smoke to the other side, harming the other person. That wouldn't be really considered in this, would it?
There's another case for mediation then. See, if it is coming to my house, I settle it. He says, okay, I will ensure that it has come to my house. Turns the chimney and points it to Nikita's house. The you both come back to and file a suit, and that comes to mediation. In mediation, it is always a dispute resolution between parties to the dispute. Except in community mediation, where it concerns the entire community and would be binding the entire community, it binds only the two parties. The provision, similar provision like Order 8, representative suit that exists in CPC may not happen in the mediation process unless it is community-based mediation. For the simple reason that the affected parties are not in mediation, they are not in court either. And mediation is restricted to parties who are actually in dispute or in conflict. Well, Nikita, if that is the case, please remember lawyers also have a benefit from them. Nah? One lawyer benefits because I engage him and I turn the chimney to yours. So your lawyer will benefit, yeah? It's a win-win situation for everybody, yeah?
It's a good professional courtesy extended to the other one who gets it.
Yes.
And it's in strife of, I think, completing on time, we have one last question from George. George, could you please go ahead?
Good evening, sir. Am I audible?
Yes, you're audible.
Yeah, so I just wanted to ask one question, particularly with something that actually happened. Is it all fine, sir? Yeah. Hello.
Yeah.
Yeah, sir. So the thing is, if you look at the Ayodhya case in particular, sir, it first was a case that actually went through a lot of litigation for many years, and then it went into mediation, sir. After that, sir, that very same bench that felt that it could not, the bench that referred it to mediation, then in mediation it failed, sir, and then after that from mediation it went back again to litigation, sir. So if you look at it, sir, I don't know, sir. Don't you not see that as mediation being used as a pressure tactic to just solve a case?
It's a perspective again. If you want to use mediation as a pressure tactic, inherently it is not possible because in mediation there is no pressure at all.
Right.
Okay. Now, if you feel that there is a pressure tactic, if you feel that your cases are being referred to mediation to pressurize you, you have the unconditional option of saying, I'll walk out of mediation on the very first day, saying I don't want to participate. Now, misuse of a given provision is possible in any law, Right. But in mediation, it doesn't assume importance because the opposite party who feels pressurized has this right of withdrawing from mediation. You simply say, I don't want mediation, and the case goes back.
So actually, I mean, to that, if may I just add, so I mean, if you look at it, sir, I mean, the very specific committee for mediation that was appointed by the Supreme Court, sir, one of the members, sir, I mean, was not, I mean, of that particular bench, of that particular committee, sir, um, was actually considered biased towards one particular party. And when he was asked to actually just step down from the committee, he refused to do so, sir. And the mediation actually continued. Uh, I mean, of course, it's a different thing that it went into litigation after that, and they could not
No,
get into.
could you please repeat this? Your voice is breaking, so I couldn't get this.
Right, sir. Am I audible right now, sir? Is it
Yeah.
fine now? Yes, sir.
Please
So I was
closer to the mic. Come closer
Right,
to your mic.
Is
Yeah.
that-
Yeah.
Yeah, sir. No, sir. I was just asking, sir, that I mean, like you mentioned about how if we are not comfortable with one particular, I mean, person who is on the mediation committee, we can always withdraw. We can either ask for a separate mediator to be another mediator to be appointed, or for that matter, you can always walk out of mediation. So the thing is, actually, I mean, in this, why I took this particular case was, so it's because the mediation committee, which was appointed by the Supreme Court, there was actually one member on that committee who was considered to be biased for various reasons towards one particular party of that particular of the Ayodhya case.
By whom? By whom?
Sir, I mean, like I think it was Sri Ravi Shankar, sir.
No. Who felt that this person was? Let's not take names. Let's not take names.
Yes, sir.
Who felt that one person was biased?
Who felt that sir, that was the Muslim party, sir.
Whatever. So one party felt that one of the parties to the mediation, the mediator, was biased.
Yes.
So he had two options: either to walk away from the mediation or go back to the Supreme Court and ask for another mediator, which didn't happen. So it is permissible. That depends on how realistic is your view of bias.
Right.
Bias must not only be done, but should not appear to be done, is what the Supreme Court says. So if there's reasonable ground, you should have gone back to the Supreme Court.
Right.
So,
Yes,
okay,
yes,
then.
thank you so much. We have Rajiv sir, and just before that, I just want to ask Thankachand sir and Push ma'am, can we take one more question? Is that possible?
No. They are not in the picture. I'm holding this. I'm controlling it.
Rajiv sir, please go ahead, sir.
I am controlling this session. Therefore,
One question, sir.
number of questions.
Okay,
Sir,
my
okay,
question.
proceed, sir. Okay.
Sir, am I audible?
Sir, one question, sir.
Yes.
Am I audible?
Just 1 second. Ravi sir, there's a lot of noise coming from you. I'm going to mute you right now.
No, not from my side. From my side, there is not.
Yes.
Yes, sir. We've
Am I
just
audible
muted
now?
Ravi sir. Yes, sir, you
Little
are.
bit-
Rajiv sir, you are.
Any disturbance from my side?
No,
sir,
go
no.
ahead. Go ahead, Mr. Rajiv.
Sir, my question is, when you say this court annex mediation, in this, at times there are private parties, and at times one person is individual, other side is institutional or government department. Why it is so that most of the government departments are not interested to go to the mediation route, and in those cases, these kind of processes are not happening and are not getting succeeded also.
That is a huge question, which will take me a long time to answer. But I will try and give you.
I'll relate it to a particular case.
No,
I mean,
let me give you an answer. Let me try and give you an answer, specific
Please.
answer to this.
Please.
Governments, as a rule, have avoided mediation processes. Okay. Now, let's say there's a statutory order, and that is questioned by a petitioner in a government order. Now, the legality of the order is not a question that which the mediator can go into. Suppose the order is inherently illegal. I cannot clothe it with legality even by consent of parties. Therefore, in such cases, it has to be only a judicial determination, because it is a question of government exercising statutory or executive power. Therefore, there is a problem there. But statutory corporations are coming in for mediation nowadays. That is one part of it. The second part of it is, even in statutory corporations and governments, the policy that they seem to follow is to say, cover your backside is the policy. Why should I take a decision, Baba? Let the court decide. Tomorrow, the cabinet committee questions it, the managing director questions it, the public accounts committee questions it. I show a decree and say, here is the decree of the court. I am not. So that decision making, nobody wants to take.
Okay.
Yeah.
Yes, sir. There are two questions in the chat box.
I mean, a related question to this is that the way the things are moving, and if before going into mediation, one has to compulsorily go for mediation. I mean, before going to the court, if one has to compulsorily go for mediation as is being proposed and being enacted, also is likely to be enacted also. So in that case, in that kind of scenario, what kind of proposition you foresee?
No. That's a very dangerous question for me to answer. But I will rest with merely saying that if mandatorily pre-litigation mediation is to be made mandatory, then there are corresponding issues that arise, which means we need to have trained body of mediators, competent mediators, ethical standards have to be maintained, all these issues arise. And so I would much rather stay away from it right now. Maybe in another session we will do that, if you don't mind.
Aditya, there are two questions in the chat box. Please read
Yes,
it.
sir. Yes,
Yes,
sir. The first one's by Ranganathan. Ravi sir wants to ask a question for a long time, but there's a lot of background noise coming in. Ravi,
mediation
sir,
only for civil litigation or criminal cases
yes.
also applicable. As of now, it's applicable only for criminal cases. But if you believe that section 138 of the Negotiable Instruments Act is criminal, then that mediation is applicable there also. But for all other cases, mediation is not happening, except in 498A cases before the FIR is lodged. There are pre-litigation desks which have been created after the judgment of Rupa's case. It's been created. Otherwise, criminal cases as a matter of rule is excluded. If you were to read para 27 and 28 of the AFCON's judgment, the Supreme Court lists the kind of cases that can be referred to mediation and cannot be referred to mediation. Yes. Then, given the paucity of time may not be okay.
So the second question is, during the process of mediation, if one party is satisfied with the mediator,
sir, one question, sir.
The other is...
Please.
Can you ask another mediator? Ravi sir, I think Ravi sir, we shall take you in just after this.
The question that is asked by Asha Purna is that during the process of mediation, if one party is satisfied with the mediator while the other is not, can he ask for another mediator? Now, yes, he can. But the question is, why are you unsatisfied? There can be multiple reasons. Either that the mediator is partial, or the mediator has ceased to be neutral, or that the mediator has become advisor and counsel to the other side, or that he's forcing you to do something. You have an unconditional right to say, I don't want this mediator. The reason can be that I don't like his nose. You don't have to give me the reason. I don't like the way Shiv Kumar looks, man. I don't like the glasses he wears, so I don't want him as mediator. No problem. No problem. Nobody will ask you why. The least of all me. So you have an absolute right. Dissatisfaction for any reason whatsoever, you are free to withdraw from mediation or ask for another mediator.
Got it. So I think Ravi sir has been trying to ask a question. Ravi sir, could you please unmute yourself?
Yes, sir. Yes, sir. Sir, good evening, sir.
Yes, Mr. Ravi.
Good evening, sir. Yes, sir. Sir, all small litigants from the remote villages, sir. Majority of the small litigants from the remote villages, sir.
The majority
any of the villagers, they don't know about the mediation system. They don't know about this system, sir. But how the villagers, the remote villagers know about this system? Whether any court premises is available like such a system of this mediation, sir?
Your voice is not here, but
is available, sir.
But I understand there's a lot of disturbance, but I understand your question as what about the small villages and disputes in the rural village areas? Do they have access to mediation? They don't even know about mediation. That's your question?
That's what I could.
Exactly, sir. Exactly, sir.
All right. Now, this is one of the peculiar scenes of India, where the scenario, the society and the social value systems in India is still running in villages on the basis of authority, the head of the family, the karta of the family, the panchayats, and so on and so forth. So the justice delivery system is controlled by those things. Now mediation has to make an inroad there into the level, into those places. Legal Services Authority is today, at least in Karnataka, we have trained mediators in every taluk at the grassroots level. We do. But this cultural barrier where a typical villager in a family, let's say a village has some 200 houses or 300 houses, who have survived for 30 long years or hundreds of years on the head of the family, the karta of the family deciding all issues, is very, very difficult to change their mindset and come to mediation where we tell them, hey, yeah, you can decide. They'll say, why? Who am I to decide? My father-in-law is deciding. The head of the karta is deciding. There is a problem. But the facility of mediation is definitely available. Therefore, what has happened is, at least in Karnataka, the research has been carried out by a law firm, which shows that there are other forms of dispute resolution that are happening. Religious heads of religious institutions are entering into this field of mediation. But mediation, unfortunately, in India today is urban focused, metropolis focused. It's not rural focused. And I for one believe that it's time we moved into the rural areas. That's the best way I can answer that question for you.
Sir, I think we can conclude it now because we are running late.
Thank you, sir.
Yes. So,
Shiv Kumar sir, I think all our young friends present here, they will agree with me that we all are grateful to you for explaining to us the concept of mediation.
Exactly.
Essence in such a detailed and lucid manner, I would say. So thanks a lot. And I think we will need you again and again for other classes also, because the way you have carried on with the students and your interaction with the students was so good. I am quite sure that all these students must be quite satisfied with this session.
Well, I hope so, because I have not seen any negative response, but it's a great pleasure being with all of you. And I really enjoy interacting with students. My whole purpose now in life is to simply share the knowledge. So anytime available, please do share with your students my email ID if you want.
Yes.
And they are free to send whatever clarifications they want. And if there is a demand for this, if they want the PPTs, I will share it with you. Please ask them if they want it. Okay. Because they are only, Mr. Tankachan, they are only trigger points. There is no matter there except a trigger point. So it may not be useful to them.
Sir, if I may chime in just 2 words, I wanted to thank you for this session, and it has been absolutely wonderful. We've read your writings, your articles that you've submitted, but it's lovely to see you in person as well, sir.
Thank you.
I apologize in advance, but I will definitely be stealing the coconut example that you gave, because that's absolutely amazing and so easy to understand, sir. And if you have any kind of a dispute later, sir, please come to mediation. I have a lot of people that I know now who are experienced mediators, and they'll help us out in that. Anup sir, Push ma'am, Tankachan sir, thank you so much, sir. This has been a wonderful session for me as well.
It was nice having you here with us.
Thank you, Mr. Tankachan. Thank you, sir.
Thank you, sir.
Everybody.
It was a wonderful session, and so many senior friends that send messages to me. Such a beautiful presentation, sir. Such a beautiful presentation. What about Pushpaji?
No, she said she's logging off. She said she's logging off for some other. She sent a message.
No, I'm here, sir. I'm here. I'm here for a few minutes. But thank you so much, sir. Very simple in very simple words. Rather, I would say we have learned new ABCD of elements of mediation from you today. Not just they, but we also have learned. There are new definitions of ABCD of mediation which has come on floor from your presentation. Thank you once again. Sir. Thank you.
Ma'am and Garibala ma'am also send messages.
Yes. We have Veena Relly ma'am also with us. Umaji is here with us. Giribala madam, they've all been putting up comments of how beautiful this presentation and simple presentation you have laid before students. And they'll be addicted to your classroom now.
Okay. So you give me some more chances. I'd love to share something more with all these guys.
Certainly. Sangeeta Mehrotra ma'am is here with us. Amin, Mr. Amin. Yes. Punita, Jyoti.
Jyoti ma'am.
Yes, I can see Raj ma'am was there.
Yes, Punita ji is there.
Okay, that's nice. Yes. I'm glad they enjoyed it. But on public platform, I'm offering you unconditional time, my time, anytime you want.
24/7. Sir, 24/7.
24/7.
24/7.
Thank you.
All right. Thank you so much.
Okay,
Thank you, students.
Thank you so much.
Thank you, Arti, for this wonderful moderation. Thank you.
So with your permission, let me sign off the program, sir.
Thank
All
you.
right. Thank you so much.
Bye-bye.
Good night.